an indictable offense usually carries a higher sentence than a summary offense. Primarily because it's they usually are more serious, or they usually are more serious, or they carry the legislation prescribes that they carry a greater sentence.
And understanding this is going to lead to my next question. Why do you believe, as a defense attorney yourself, why you believe the DPP office decided to lay the charges indictably as against doing it summarily?
Well, from what I understand, this wasn't a decision of the DPP's office. It was actually a mistake by the complainant, the police officer. He laid the charges wrongly. Where Her Worship Magistrate Sideno laid blame on the DPP's office is that they didn't seek to have the charges withdrawn and then fresh charges laid within the 6-month time limit as prescribed by the legislation. So in terms of laying the charge, the actual error, from what I understand, and I'm willing to be corrected at any time, lay in the hands of the police. In the laying of the information, it was supposed to be a summary complaint as opposed to an indictable information, and that is where the issue began.
And it's amazing, though, because even though you said that we can see that the DPP office was not the one laying the charge, yes. One part of the error that the judges are happy about is because, listen, it's not the first time this came before me. You guys had enough time to look at this.
Indeed so.
Why you think this was an oversight? I mean, it does beg the question, am I looking at incompetence here, really?
I would, having had personal interaction with the director himself, I would say categorically he's not incompetent. What it boiled down to, respectfully to all parties involved, was an interpretation of the law. Perhaps it was that the DPP's office saw that the defect was capable of amendment, and they left instead of going through the process of withdrawing and relaying the charges, they simply sought to have the matter amended, as opposed to withdrawing it and relaying it summarily. But I would not go so far as to allege incompetence, not against this particular director or Mr. Busby, who handled the charges, who handled the arguments for the charges.
Okay, just as a question, because when you look at one, they were charged under gang legislation, they were charged indictably,
yes.
and you asked the question, was it a case of manipulation of the gang legislation, the intent of it, ignorance of it, negligence, or incompetence? I should have put all those options on the table, because if you're in the middle of doing this, you must understand that you have to be very careful and specific with why you're charging indictably as against summarily.
Yes. Well, judging from the facts that have been put out in the public domain, the section itself is not very clear. The section, which is section 5.1a of the anti-gang legislation, and I suspect perhaps it was misread by the officer laying the charges, so that he thought that an indictable information was what ought to be laid as opposed to summary information.
Now, let me see if I can get this clearly, because this is education for me. So the officer looks at the situation and he decides he's going to put a charge. Is there anyone legally based? I mean, is there an attorney that's going to look at this and say, yeah, these charges, this is fine to go ahead with it, with this charge as against maybe you misunderstood something? I'm trying to understand if the officer doing the charging must be an attorney or quasi-attorney.
No, the officer doesn't have to be an attorney, but the police officers are trained to look at the criminal legislation and to understand what sort of offense ought to be charged. Now, the problem wasn't that he charged the wrong offense.
No, the right offense.
Is that he put it on the wrong form.
The wrong form. Okay.
So it could be that he got instructions from the DPP to charge with this particular offense, but the DPP is not involved in the particulars of writing up the form. So that is where the mistake lay, in the particular form that he used to go before the magistrate.
Now, in about 3 to 5 minutes, you made it very clear to me, and I understand your representation of the legislation and so on. I am trying to understand the judge saying there was a mix-up in varying sentences for the two processes, and she's asking for us to take a closer look at this, asking that this legislation be given a second look. Why?
As I said, the legislation itself, as I am a member also of the Criminal Bar Association, which is the bar association which represents criminal defense attorneys. When this legislation was being drafted, we sent several comments to the government, which was the last sitting government. We sent several comments to them, a large majority of which were ignored, in particular about the way in which these sections were drafted and the powers that were given to police officers and the powers of detention. So with respect to this particular section, it's badly worded. It's plain talk bad manners, to use the colloquial term. It's badly worded, and the legislature should look to address that in terms of specifying, because it seems as if the section says initially you are charged with a summary offense, and then any subsequent offense you would then go on indictment. But it's not very clear. So it took me 2 looks at it to ascertain that. So I can imagine that on a cursory glance you would think that it's either summary or indictable, and you can go either way.
Let me continue with my education from Attorney Raphael Morgan, who is here this morning. This means that if we have one person walking free, because that was the only charge he had, which was gang-related, while the others are standing trial for other charges, but as far as that is concerned, being charged, that case against them is automatically out.
Under our summary courts legislation, which is section 34, a summary offense, as it's been clearly established, this offense is a summary offense. You can only charge them within 6 months of the offense having arisen. So from the time they engaged in the gang-related activity, you have 6 months from that particular offense, from the origination of that particular offense, to charge them. Now, if you are going on the same facts and the same information,
nothing has changed.
Nothing has changed. Then you will be outside of the statutory time limit. So with respect to that particular offense, the state cannot proceed against them anymore.
Roughly translated, as I'm very clear, nobody who were charged indictably can be held up for that anymore.
Well, not in terms of serving a sentence for it. It does not preclude the state from using the information at their murder trial. The information, if the state does indeed have that information, that they are related and that they are engaged in gang-related activities, and that those gang-related activities contributed to the death of Ms. Sita Hall, the fact that these charges are dismissed does not preclude the state from leading that information either at the preliminary inquiry or at their trial, if it gets that far.
Senior Magistrate Cedino was not very happy with this. I assume the DPP office would not be very happy.
No, knowing Mr. Busby and the DPP, they would not be very happy about this.
This particularly at a time where the DPP is trying to get more people to have confidence in one of our many institutions that uphold laws. Now, because we have one person walking, others who are going to walk on that particular charge, we would have to look at ways of tightening this whole area of the gang legislation. You said there were areas where there were questions raised by your association. What are the top 3 priorities you would like to see tightened in this legislation or clarified?
With respect to, we had an issue with the length of the detention without bail.
6 months, is that right?
120 days.
120 days, thank you.
120 days without, that was one of our major issues. We also had an issue with the ability of the information that the quality of the information that the police would be putting forward in order to charge individuals with gang-related activities, because there is no quality control over that information, which we saw with the state of emergency, where almost everyone who was charged with gang-related offenses, those charges were dropped. And they have now, several of them have now brought actions against the state for wrongful arrest, false imprisonment, and malicious prosecution. So those are some of the areas that we highlighted when we were looking at it and offering our comments. Unfortunately, large amounts of our comments were ignored. I can't say why. Well, at least not on air, but we are left with the legislation that we have today.
It's a very tough place for a lot of folks who are looking at that, because although there is much more to come from it.
Indeed so.
Explain the wife of one of the accused. Was she given, because she was charged with benefiting from gang activities?
Yes.
Was she given, in fact, bail, was she? What was bail?
She was, I believe.
Because it's a separate charge.
Because it's a separate charge. She was charged with both being a gang member and doing an act which benefited a gang.
Mm-hmm.
That charge was laid correctly. So she remained in custody.
Mm-hmm.
She remained in custody. One person was freed. Two persons were freed, but one was rearrested as he was leaving because he had outstanding warrants
for something else,
for unrelated criminal activity. So with respect to her, as she was facing two offenses, and I believe the second offense is a non-bailable offense as well. So she had to remain in custody.
Gally Cummings is standing by. He will be joining us shortly. Our opportunity now we're taking advantage of is having Attorney Raphael Morgan with us, and we're looking at the dismissal and the scalping, or rather the hard knock on the wrist from Senior Magistrate Cedeno in the case of the accused going on. I am trying to understand just one part of this that leaves me totally confused, Attorney Morgan.
Mm-hmm.
Why? How is it possible for you to have had these charges laid? You have the eyes of the DPP office. I know I asked you this before. I'm coming back here because I'm not accusing or trying to extract from you anybody incompetence on anybody's behalf. Mm-hmm. I'm just not understanding why nobody saw this.
Well, as I said, I can't speak for the minds of those who were there. Mm-hmm. However, I do have personal experience with some of the attorneys who were involved, at least on the side of the state.
Mm-hmm.
I know their competence. I know they are very competent. I can only offer, looking from the outside, one explanation is that they were of the firm view that it could be amended and an amendment would cure any defect. Now we have to remember that the summary courts legislation in section 118 prescribes that no objection should be taken in form to any complaint or charge laid.